Hello and welcome to Bird and Birds, A New Era, a podcast where we unpack the most transformative changes to UK employment law in a generation, the Employment Rights Act 2025. The Act is a vast framework of enhanced rights, touching almost every aspect of the employment relationship. It represents a fundamental reset of the balance between employers and workers in the UK. Whether you're a business leader, HR professional, line manager or employee, this series aims to break down the key changes, explain the practical implications, and help you understand what to prioritise now to stay compliant and prepared in the months ahead. I'm Olivia Baxendale, Knowledge Development Lawyer in Bird and Birds International Employment Team, and today I'm delighted to be joined by two colleagues, Tim Spillane, a partner, and Kate Hearn, a senior associate. In today's episode, we're focusing on one of the most consequential changes under the Act, the reform of the unfair dismissal qualifying period. This is a major shift that will fundamentally alter the risk profile for employers. And with a 1st of January 2027 commencement date fast approaching, now is the time for employers to start planning. Kate, the government has described its package of employment law reforms under the Act as the biggest upgrade to rights at work for a generation. But before we get into the detail, can you give us a sense of what is actually driving this? What is the Act trying to do and who is it aimed at helping?
Well, you might recall back in July of 2024, the King's Speech confirmed the new Labour government's intention to introduce the Employment Rights Bill. The headline-grabbing element of that was that it would be brought in within the first 100 days of government. It was framed around Labour's plan to make work pay, which was a central pillar of its manifesto, and it was billed as the biggest upgrade to workers' rights for a generation. That proposed bill then became the Employment Rights Act in December last year, and this new legislation shifts the dial firmly in favour of employees after more than a decade of broadly pro-employer policy under the previous government.
Thanks, Kate. And before we get into what is actually changing, let's just take a moment to, remember where we currently are and where we were. The qualifying period to bring an unfair dismissal claim has, of course, been 2 years since 2012. Now, Tim, could you cast your mind back to that change and what it felt like at the time?
Yes, thanks, Olivia. So before 2012, the qualifying period was 1 year. And the increase in the qualifying period to 2 years at that time was mainly driven by economic reasons. So the coalition government of the time estimated that it would create business savings of around £40 million a year. It was also intended to reduce pressure on the employment tribunal system and increase employer confidence when hiring new staff. So it reflected a broadly pro-business policy approach at the time.
And Kate, do you think from an employer advisory perspective, did that change in 2012 make a tangible difference, do you think? Did businesses actually feel the benefit of having that 2-year buffer?
I recall that change happening fairly soon after I qualified, and I was certainly very aware that it felt like a fairly seismic change for our clients at the time. I think there were probably two main benefits of the qualifying period being lengthened at that time. Firstly, the 2-year period gave employers a meaningful window to see whether issues with employees were fundamental or just teething troubles that could be worked out. So it may well have avoided some dismissals. But then, secondly, and I suppose this is the flip side, it made some dismissals potentially much more straightforward. And by that, I mean without an obvious protected characteristic in play, an employer could have a meeting with an underperforming employee at any point before the 2-year mark and part ways without the same level of procedural exposure. So I think that flexibility was highly valued by businesses, but we're now seeing that being legislated away.
So let's get to the heart of it. Tim, what exactly is the new qualifying period and how did we end up with that rather than the day one right the government originally wanted?
The government's flagship policy, as Kate said, was to make unfair dismissal protection a day one right, so completely removing any qualifying period. But following opposition in the House of Lords, this was amended to a 6-month qualifying period. The day one protection against discrimination and automatically unfair dismissal still remain. But from the 1st of January 2027, the qualifying period for unfair dismissal claims will be reduced from 2 years to 6 months.
Is 6 months actually a meaningful compromise, do you think, Kate? Or is the practical impact for employers almost as significant as day one would have been?
I think in practice, the impact will depend on the nature of the business. So for many employers, and I would say particularly small and medium-sized companies, the honest answer, I think, is that 6 months is probably almost as challenging as day one. And that's because the window in which you can genuinely assess a hire, run a structured probationary process, and act without procedural risk has become very narrow. And all of those components require potentially significant HR and managerial resources.
Yes, I agree. And I think sometimes people focus on the threshold change without thinking about what happens once you are inside the window of protection. Tim, maybe you could provide a quick reminder. What does an employer actually have to do to fairly exit someone once an employee can bring a claim?
So to dismiss an employee fairly, an employer's got to have a fair reason and follow a fair procedure, basically. So, for example, in a poor performance scenario, the company would need to go through a performance improvement process, which would need to include setting measurable targets, allowing adequate time to improve, having review meetings, issuing warnings, and so on. And when you factor in the period that would normally be spent training and also onboarding new hires, it becomes a short period for employers to identify and act on underperformance before that 6-month window closes.
And Kate, let's think a bit about probationary periods, because presumably the way those have traditionally been structured now needs a rethink.
Yeah, I think 6-month probationary periods have been really common until now, but they'll obviously need to be shorter than that to remain practical and effective. I would say that a period of around 3 to 4 months will likely become best practice. And actually, on a related note, it's important to also touch on notice periods, because employers will need to be aware of how these might affect the dismissal process and might require additional time to be factored in after the probationary period has ended. And a key point to remember on that is that the minimum statutory notice period is added to time actually worked when calculating service for the unfair dismissal qualifying threshold. So you can dismiss someone just before 6 months, but their statutory 1-week notice period would be added on, and that might just take them over the threshold, meaning that they would qualify for unfair dismissal protection. So definitely something to be mindful of.
Absolutely, really important there for employers to be remembering that. And maybe turning to the scale of the impact of this threshold change, just how many more people are we actually talking about who can now bring potentially an unfair dismissal claim? Because I think the numbers are potentially quite striking.
Yeah, they really are. And I think that's one of the reasons that this change has generated so much interest. Research conducted by the Department for Business and Trade found that approximately 6.3 million employees have been working with their current employer for between 6 months and 2 years. So that's around 22% of all employed people aged 16 and over who will gain this protection. So in turn, that represents potentially a huge increase in the number of unfair dismissal claims from early next year.
And I think we should also bring in the wider litigation landscape here, because this does not exist in a vacuum. And Tim, turning to you, what is the current state of the employment tribunal system, and what does adding a further wave of potential claims actually mean in practice?
Well, at the end of the third quarter of the 2025-26 tax year, there were 523,000 claims going through the employment tribunals, and the average wait time to resolve a claim had increased to 31 weeks by March this year, which was 63% worse than the year before. So claims taking longer to resolve. There's a current sort of widespread opinion, really, that the tribunal system just isn't coping and that claims are taking longer and longer to be heard. The government has said it intends to take action and digitalise the tribunal system and increase efficiencies, but the impact of that remains to be seen. And as it stands, backlogs are already significant, and this higher number of eligible claimants that Kate pointed out are very likely to make the situation worse.
Absolutely. And there is a slightly uncomfortable point here about the way backlogs shape the strategic dynamics of a claim. Kate, can you explain what we mean by that? How does a 2-year wait to a hearing actually affect how parties behave?
Well, from an employer's perspective, I think a long wait cuts both ways, actually. On the one hand, it can be really unhelpful, and we do tend to find when acting for employers that delay can erode the reliability of evidence that they're seeking to rely on. So, for example, key witnesses can leave the business in the period between receiving the claim and then actually getting to the hearing. Documents can get lost, memories can become hazy, and all of that makes a winnable case potentially much, much harder to defend when you eventually get to tribunal. But on the other hand, claimants also have to live with that delay. And this this can actually be helpful for an employer. So if a claim takes 2 years to be heard and the employee has found equivalent work in the meantime, their recoverable loss will be limited. And so actually you might find that the prospect of going through with their claim becomes less attractive, and settlement might then become a bit more likely. So I suppose we tend to see that delay can create strategic tension, which can help employers' prospects, or in some circumstances, it can actually increase the risk over time.
And there's also an interesting point here, I think, Tim, about the changing nature of the evidence itself. This is not just about more claims, but about the quality and the volume of evidence those claims are supported by. Has that shifted, do you think?
Yes, I think it has. I mean, the increased digitalization of the workplace, increasing widespread use of email, messaging platforms, social media, and so on, has definitely created more documentary evidence in cases. And claimants are using all of that to support their grievances and subsequent tribunal claims. So, as an example of this, in 2019, 150 employment tribunals across the country used WhatsApp messages as evidence. But by 2024, so 5 years later, that figure had increased to 427 tribunals, a marked increase. And AI is, I think, only going to exacerbate this. It's making it easier for claimants to draft and pursue complaints with less professional support. And we're definitely seeing that in the documents and correspondence that's crossing our desks.
I agree. I think we're all seeing an uptick in AI use by employees and claimants, and we could probably dedicate an entire podcast to discuss that topic. But turning back to the unfair dismissal threshold, so given everything we've just discussed, can we share maybe some practical tips on the steps employers should be taking between now and January 2027 when the 6 months qualifying period comes in?
Yeah, and I think before we dive in, it's worth mentioning that employees who have completed 6 months service by the 1st of January 2027 will immediately gain unfair dismissal protection on that date. So anyone joining a business from July this year will gain that protection if they're still employed on the 1st of January. But it's not just people from July that you need to be thinking about. Obviously, those joining before July will also no longer have to wait the full 2 years anymore. So this is all relevant for recruitment decisions that you're making now, basically. I think my first practical tip is to ensure proactive performance management is absolutely front and center of everything you're doing in this respect from now onwards.
And presumably that links back to the hiring stage as well, as you mentioned. If you have less time to review performance, don't you need to try to get the hire right in the first place?
Yeah, that's exactly right. That would be my second tip. I think reviewing recruitment and onboarding processes to ensure that there's a really robust and clear process built in for new hires will be really important. A 6 month service threshold puts so much more pressure on the outset of the employment relationship. So there needs to be more focus on getting the right candidates at the outset and also trying to get them settled into the business to see if they're reaching their full potential so that you can make decisions about new hires pretty quickly. And frankly, the shorter 6 month time frame means that recruiting the wrong person will carry far greater financial and administrative consequences going forwards.
There's also a point here, I think, that employers might not immediately think of as well around pile-on and notice provisions.
Yeah, and that would be my third tip, actually. Coming back to that notice point I mentioned earlier, now is the time to check employment contracts to ensure they include express pile-on clauses, enabling employers to terminate immediately before an employee reaches 6 months service. Without an express pile-on clause, making a dismissal in this context could not only constitute breach of contract, but could tip the employee's service beyond the 6 month threshold. And timing is absolutely everything, because an employee dismissed with immediate effect just before completing 6 months service could still qualify for unfair dismissal protection if their statutory notice period of 1 week would take them over that threshold.
Thanks, Kate. That last point in particular, I think, is one a lot of employers may not have on their radar, so a really important flag. And Tim, turning to you, is there anything else that employers should be thinking about? What about probation periods, for instance?
Yes, I mean, I think that would definitely be a fourth tip for employers to look at probationary periods and consider restructuring them. So Kate touched on this earlier. 6 months probation periods are commonly used, but companies will now need a probation period that ends in good time before that. 6-month period. And so using it effectively to make fairly quick decisions on new hires. I mean, as we said earlier, we think a 3 to 4 month probation period should provide enough time for employers to assess performance, but also give them sufficient time to actually go ahead and dismiss if they need to before the 6-month mark is reached.
That makes a lot of sense. And I guess presumably that has a knock-on effect for the people actually carrying out those probation reviews, who will usually be the line managers and HR teams on the ground.
Yeah, that's right. I mean, Kate mentioned just a second ago that it's really important for employers to pay close attention to both the initial hiring process and then proactive management of the employee's performance in role. And yeah, I mean, line managers and the people actually sort of on the ground here are going to need updates on these upcoming changes and why they're important. And if necessary, training on how to manage their new staff's performance properly, as well as ideally all existing staff. So, for example, there may need to be sort of refreshers on performance management, holding difficult conversations, how to manage probation reviews, and so on.
Thank you both. Those were helpful and practical insights. As today's discussion has made clear, this is not something employers can afford to leave until later in the year. It's an issue that needs attention now. One area we haven't explored today is the removal of the cap on unfair dismissal compensation, which is also expected to come into force in January 2027. This is a momentous change that significantly alters the financial risks for employers, particularly for senior exits, and employers will need to rethink their approach to high earner exits and settlement. We'll explore this in much more detail in a future episode. But for now, a huge thank you to Tim and Kate for sharing their expertise. We hope today's discussion has helped to break down this aspect of the Act and given you a clearer understanding of what's changing and why it matters. If you found this episode useful, please subscribe, share it with your network, or visit twobirds.com for further information. Thank you for listening to A New Era, and we hope you'll join us again next time.